Hey folks, welcome back to the Wikipedia world, and I am Abhinay Gupta. And today again we are continuing with the interpretation of statute, deeds and documents. Right? And it's good to announce that we have completed all the primary rules of interpretation. Right? And in this lecture itself, we'll cover up all the three secondary rules of interpretation. Right? Yeah, which sounds a little difficult to pronounce the words over there, but yeah, those meanings or those rules are very simple, right? And we'll try and cover all the three in this particular lecture, right? And after we are done with that, we'll be done with all the rules of interpretation, and then we move on to the internal or the intrinsic aid to interpretation, and then also the external aids to interpretation, right? So should we start with it? So all those of you who have missed out on the primary rules of interpretation, please go back. You'll find all the videos over there. Know the rules and then come over here and we will step ahead with the secondary rules of interpretation. Right? So what are the secondary rules of interpretation basically? So we have three rules over there. Number one, Noscitur Sociis. Number two is Expressio Unius est Exclusio Alterius, and the third one is Contemporanea Expositio. Right? Typical names but easy meanings. So let us start with the discussion of the first rule of the secondary, that is the secondary rule of interpretation, which is Noscitur Sociis. So if you remember, then in the first or the second lecture, when we were discussing the basics, right, when we were discussing all the rules, I have given you an introduction to all these three rules as well. Right? So over there we have discussed what Noscitur Sociis actually means. So remember over there when we were discussing, I said that if there are certain words that are used in the statute, right, and you have to interpret those words independently. It's not about the interpretation of the entire statute, right? For that we have all the primary rules. These secondary rules basically are not very widely used for interpretation, right? But there are some specific cases for which we would need to refer to the secondary rules. So for the same example, if we talk about the Noscitur Sociis, right, then the word that we are trying to interpret, we will interpret it in relation to the associated words that have been used. Right? If you see on the screen, we say the meaning of the word needs to be derived from its associated words. So again, all the other words that are also used along with the specific word which is under consideration for us to interpret, right, they're all trying to get to a streamline. Right? If the statute is talking about something very specific, they are trying to talk in one direction. So all the other words that are used over there will also be pointing in the same direction, right? So it becomes easier for you to interpret a word when you know the direction into which it is trying to move, right? The context into which it is being used, the context with which it is being used, right? So once you know the context, once you know the direction, it becomes very easy for you to understand or interpret the word that would be applicable in that statute. Right? So that is why if you want to interpret a word, don't refer to it in isolation. Don't refer to the dictionary meaning directly. Right? The dictionary meaning will be referred if we are applying the rules of literal interpretation. Right? But when do we go to the other rules? That is when the rule of literal interpretation basically fails. So that means your dictionary is not able to give you the exact meaning of the word that you need. By telling that it is not giving you the exact word, I mean it is not giving you the exact word that you need to refer over here, because over here we derive the meaning with reference to the context in which it is used, right? So the words in the statute are construed with reference to the words which are found with immediate connection, right, which are found in the immediate connection with the words under consideration. And this does not only apply to a single word that we are trying to interpret, right? But if there are more than one, right, two or more words that are used in connection to each other, right, we will interpret each of them in connection to each other, right? They will all be referred to, or they will all be interpreted in the same direction, right? For this, if I take an example, then if we talk about cosmetics, perfumes and toilet goods, right, then over here when we are talking about perfumes, right, it will always refer to the associated words, that we are talking about perfumes which are related to or which are under the category of cosmetics or the toilet goods, right? That means the perfumes that you use, the deo that you use, right, those perfumes will be connected over here. The perfume that you use to fragrance your washroom, toilet goods, right? The perfume that you use on your body, on your clothes. But if you talk about the perfumes that you use in your cooler, air cooler, right, to provide a good fragrance to your room, the perfume that you use in your car, the ambipure or something over there, right? So those kinds of perfumes are not included over here because they are not cosmetics. They are room purifiers, they are air purifiers, right? They are not cosmetics. So over here when we talk about perfume, we are not talking about all the aroma, all the perfume that are found in any category, that are found in any frame, right? We are talking specifically about those perfumes that are used as cosmetics or that are used as toilet preparations, as toilet goods, right? So that is what Noscitur Sociis basically aim to demonstrate. The incense stick, the dhoop, whatever you use, right, that provides you an aroma in the air, that provides you a freshener, right, that helps you as a freshener of the air, freshener of the room, those are not the perfumes that we are talking about in this context, right? So you understand what are we trying to mean over here? So even the cosmetics that we are talking about, those cosmetics will also be related, right? That yes, those cosmetics which give you some kind of an aroma, the cosmetics that are used to make you feel fresh, right? We're talking about those cosmetics. Okay with that? Now we also talk about some exceptions in this case, that when we do not use these words. So if you look at the larger meaning of the rule Noscitur Sociis, then it says that okay, if we are talking about a particular statute, right, then in that statute if we have referred to any word and we have tried to interpret a word, that word will generally have a common meaning throughout the statute. That is what this rule aims to say, right? That okay, if we are talking about a particular statute, then the statute is prepared for a particular purpose. So if you're talking about the perfume, right, if perfume is referred somewhere in the statute and it is referred along with the cosmetic, then we are only talking about some specific category of perfume, right? We are already clear with that. So whatever the statute goes on to say about the perfume, we will always think that okay, they are talking about the same perfume that we have depicted so far, right? Why? Because the statute is framed for that purpose. So the word which has been interpreted along with the use of the other words will have a constant meaning throughout the statute. That is the general perception that we have, right? But now where does the exception arise? The exception arises where the words are used in different contexts, maybe in the same statute, right? For example, if you are talking about plant and machineries and plant and trees, so when plant is used with machinery, you know what kinds of plant are we talking about? We are talking about the fixed assets, right? But when plant is used with trees, we are talking about the tender plant, right? The biological species, right? So we are talking about plant. The plant can be anything. If I just give you a word plant, what do you think? In general, everybody would consider the plant the smaller trees that we say, right? But if we talk about the accountants, right, in our profession, people would straight away reflect the fixed assets, right? So it is very important for us to understand what is the context in which it has been used. So in the same statute, if these are used different, right, in different contexts with different words, then we will always interpret it along with the context in which it has been used, right? Now second, where there are different circumstances that are being dealt with. So a single statute is dealing with two or more circumstances, right? So maybe in two different circumstances the same word may have two different meanings. Why? Because in the different circumstances it is being interpreted as something different. There are other words that are associated that gives it the meaning, right? And those words are different in both the circumstances. So in that case we will not have a common meaning throughout the statute. It will depend, or it will change with the change in the circumstance that we are dealing with, right? So it's on the screen where circumstances are different. Number 3, where it leads to absurdity. Now okay, we are trying to refer, right, to any specific word. We are trying to gain its meaning from the related words, but if that related words they give you an absurd meaning, right, and that defeats the purpose of the statute, basically you think, why is this being used over here? We are not talking about anything in this reference, so why do we use this word, right? But in that case maybe the word means something else, right? Like if we talk about the plant, right? So if you are interpreting plant to be fixed assets, but we are generally talking about the plant in the tree genre, but we have not specifically specified trees. We're talking about some agricultural producers over there, but we are dealing with certain farmers, right? And we are dealing with the farm of the farmers. So over there we have, although we have talked about the bullocks, the machines that he's using, the irrigational facilities that he's using, the irrigational facilities he has set up, the fertilizers, the pesticides, all these are his assets. And then we also talk about plant. So we are talking about plant as an asset over here. But what plants are his assets? The plants that he is growing. It is not about the fixed asset, the plant and machinery that we are talking about, right? So although that plant has not been used with anything that reflects the biological division, right? We are not using the word trees over there, we are not using the word herbs over there, but we are generally talking about other things like the machinery, like the farmhouse he has, right? The irrigation facility, the pipeline that he has set up, the other infrastructure that he has set up, the greenhouse effect that he is giving, and then again in the assets we also include the plant, right? So over here if we consider plant to be plant and machinery, then it would give rise to absurdity, right? So in this context we will not use the same word with reference to the other words, right? Plant will have its independent meaning and it should not defeat the purpose of the statute. Clear with it? Was the example useful? Right? But this example was not taken up from your study material, right? So try avoiding these kinds of examples that are not directly from your study material, right? Because you never know who's checking your paper, right? You never know his intent, you never know his thought process. So we'll try not to use certain examples like that. So just go on in plain text that where it leads to absurdity. That is it. You don't have to mention anything beyond that. But just for your understanding I have used the example over here. Right? Are you clear with it? Okay? Right. So the last point that we have in the exceptions is that the words are used in one place will not have the same meaning throughout. Yes, exactly, that we have discussed. So if you try and understand, then a word that is being specified, right, or that has been used or interpreted in respect to any particular section need not necessarily be the same for other sections in the same statute. Right? You have to understand that. You have to understand the concept behind that. If that has one meaning for a particular section does not necessarily mean it will have the same meaning for all the other sections in the statute. We'll always have to see that what context is it being used with. Right? So that is the exception to the rules of the Noscitur Sociis. Are you clear with the rule? Any queries, any confusion over here? I hope no. Just remember one example when you are talking about Noscitur Sociis, the plant and machinery and the plants and trees. How do you construe plant to be? What meaning or what interpretation do you gain out of it? Right? If you remember this example, you will remember the entire context or the entire meaning of Noscitur Sociis. Right? And that will help you answer your questions in the examination. Okay? So we move on to the next rule of the secondary rules. that we have Expressio Unius est Exclusio Alterius. Now what does this mean? One of the most typical names, right? And you know what is the worst part? You are not given this name in the examination, right? If I refer to a question from May 2011, right, what they say is associated words should be understood in common sense manner. Explain the statement in light of the rules of interpretation of the statute. So over there they want you to specify the name of the rule, right? And they know it is difficult for you to mug up the name, to understand the name, to put it on your tongue, right? And also to remember the spelling. But you will have to do that, right? So it is Expressio Unius est Exclusio Alterius, Expressio, Expressio, right? When I say Unius, it is Unius, est, est, Exclusio, Exclusio, Alterius, Alterius, right? So unlike English, this does not give you any different pronunciation and a different spelling, right? It has the same pronunciation and the same spelling that will help you get it right in the examination, right? Just make an habit, make your tongue adapt the words Expressio Unius est Exclusio Alterius, and then everything is solved, right? So now if you have remembered the name, let's move on with the meaning and the detailed analysis of this rule. So over here also I'll take the same example that I have taken in the rules of Aegisthum Generis that we were talking about, right? The solar system, the planet. So what does this rule say? That if you specify Earth, right, that means you exclude the other planets in the solar system. If I talk about life being possible only on Earth, or maybe somewhat in Mars, the possibility that they are finding out, that means the life is not possible on the other planets like Mercury, Neptune, Saturn, Uranus and stuff, right? So this entire rule, Expressio Unius est Exclusio Alterius, it says that if you are using any specific word, right, then that would mean that you are trying to exclude the others in the same genre, right? That means if two or more things belonging to a particular class are mentioned, that means we automatically deem that the others are excluded. They are silently excluded. We are not referring to them. We do not intend, right, unless and until the general word is used, like in Aegisthum Generis, right? If we are talking about the oxen, bullock, dog, sheep, horse, right? If we do not use etc., then we do not mean any other domestic animal with 4 legs. We just mean these 5 animals, right? So that automatically excludes cow, buffalo, goat and stuff. Understanding the meaning? So if only the specific words are used, we will take it to mean that only that specific words will be counted. We have nothing to do with the other in the same genre. Why? Because the general word is not used. So we will not apply the rule of Aegisthum Generis, but we will apply the rule of Expressio Unius est Exclusio Alterius, right? And if you want to know, if you want to keep in mind and remember, right, which words, which set of words, which name of the rule implies to what meaning, then always remember, when we talk about Aegisthum Generis, with generis remember the word general, right? The general word that are accompanying the specific word, right? So you'll remember Aegisthum Generis. So similarly, if you talk about Expressio Unius est Exclusio Alterius, and we are talking about excluding the other words, so exclusio means excluding, right? With this, with just one word, exclusio, you'll understand that yeah, you're talking about the rule that excludes the other words that are not used, right? So if you see on the screen, express mention of one thing implies the exclusion of the rest. That is the meaning of this rule. So we'll again take up some examples that have been specified, right? So let us take the first example. If the statute refers to like land, house and coal mine, right, then since it has specified coal mine, that means we're not talking about the other mines, right? We're not talking about the stone quarry and the other mines. It is just the coal mine that we mean. And you will also not say that okay, since we are talking about land, right, other mines are also part of land, So we can include the other mines? No, because if you had to include all the parts of the land, if you had to include all the mines, then even the coal mine would not have been specified. So express mention of one thing, that is express mention of the coal mine, automatically implies the exclusion of all the other mines, right? Otherwise even the coal mine would not have been mentioned over here. They would just have said land, and land means all the mines included. You could have considered it that way, right? But since they have used coal mines, all of the mines are out of the scene, right? Similarly, if we take our example of the solar system, if they say the planets and the planet is Earth, right? If they talk about the planet Earth, that means we're not talking about the other planets. It is just the planet Earth, excluding all the other 8 planets, right? The other examples given are, like if the statute is trying to regulate land and building, right? We generally use the term land and building along with each other in our accounting terms, right? In our financial statement also we have a separate head, land and building, right? But if the statute specifically provides any provision for land, right, then we will understand that the buildings are excluded, right? Because land and building are generally used together, so even if the statute is providing something, they should say land and building. But since they are not using the term building over there and they are talking just about land, that means we will understand that building is not included, right? So for this we can also refer to a case, right? A case of Kimka and Company versus the state of Maharashtra, right? That was a case of tax, right? Where one provision or the first part of the tax dealt with the taxes payable, while the second part talks about the taxes and penalties. So over there what they construed is that the first part would exclude, right, the coverage of penalty. Why? Because they have specifically talked about the tax payable, and the second part has specifically included penalties, right? That means they did not intend to use penalty in the first part, and hence it was excluded over there, right? So with this, are you trying to get the meaning of what we are trying to convey? That the words, if one word is used specifically, then it automatically implies the exclusion of the rest of the words, right? Because if they are using tax and penalties together, then why did they use taxes payable separately? That means they did not intend to use the word penalty, right? So this rule basically is used in your day-to-day life, whenever you are studying a subject of law also, right? You generally interpret it that way. You don't think that, okay, I'm thinking in context to the rule of Expressio Unius est Alterius, Exclusio Alterius, right? You do not think like that way, but you actually are applying this rule day in and day out, right? So now if we have done with examples also. Now there are 2 cases of non-applicability of this rule, right? Number 1 is where the words are clear. Where the words are very clear, if everything is given straightforward in front of you and you can apply the rule of literal interpretation, then you will not go ahead with some other rules, right? We know that already. Now take an example that, okay, the rule of literal interpretation fails to achieve the objective. So in that case only you will go ahead and apply this rule, because this rule has to be applied with great caution, right? Why? Because it is the responsibility of the interpreter, that is the court, right? If it gets into a wrong interpretation, then there is a blunder being made. So it's the responsibility of the court. He has to use this rule very carefully. So if literal interpretation works, we will not go ahead with this, will not include any other thing, or will not specifically exclude something, right? If it is generally working out. But if we are talking in specific context and it is not generally working out, then we may need to use this rule, the rule of Expressio Unius est Exclusio Alterius. The reason why I am always telling the full name is that it helps you to seep it down into your brain, right? When you are using your eyes to look at it and your ears to hear it, and also your mouth when you are uttering it after me, you are learning the name, right? And this rule will also not be applicable where there is an exclusion by an accident. That means while drafting the statute, right, The legislature, they wanted to bring out a meaning in the statute, but the draftman who has drafted the statute, right, he missed out on any particular word because he did not specifically think of including it, although in general terms it is included over there, right? So that is considered to be an accidental exclusion, and if at that point of time we apply this rule, right, the rule of Expressio Unius est Exclusio Alterius, then what happens is that you get to exclude those specific words, whereas that would actually have to be included as per the statute. So you are making a blunder there, right? So in such situation we will not use the rule if there is an exclusion by an accident, right? And that is very much evident. If you look at the statute, you understand that okay, they did not mean to exclude it and there is no reason of excluding it, but since it is not specifically and exclusively included over here, right, and if we apply this rule, that we would end up excluding it, which is not actually required, so we will not apply this rule over there, right? Got the meaning, got the examples and the non-applicability? That is all about this rule as well. And now we move on to the last rule, which is Contemporanea Expositio, right? Again, to remember, contemporary, when we're talking about contemporary, we generally refer to the old things, the things that have been established, right? So if you remember, then when we were talking about this rule, we said that we are dealing with the old statutes, and I had taken the best example, right? Although that example is not mentioned over here, but if you remember the example that I had taken, right, the calling of the board meeting, right? How is the board meeting supposed to be called? The statute as per the 1956 said that the directors had to meet in person, right? But even before the application of 2013 Companies Act 2013, like somewhere in 12, 11, 10, 9, 8 also, you always used to allow holding a meeting via video conferencing channels, but that was not exclusively included in the meaning of holding the board meeting, right? So what interpretation did the court and the statute and the framers and the users of the statute, right, they took, is that they said, okay, at the time of enacting this statute, right, when the legislature enacted a statute, the Companies Act 1956, they did not know about the video conferencing. This concept of video conferencing was an alien concept for them, right? So they did not include it because as per that time you never had video conferencing, so there's no point of including it. But later on, video conferencing, the system they developed, right, and that was very much similar to like having been seated in front, you're virtually in front of each other. So that was generally acceptable. And how did they generally be acceptable? They were generally acceptable actually because of applying this rule of Contemporanea Expositio, right? And later on in 2013, the Companies Act 2013, they have specifically provided for this, that any audio-visual channel and video conferencing would be allowed if you can identify the director, record the date and time, and do all other procedures, right? So that is the best example of Contemporanea Expositio. So you got the meaning on the screen? Interpret with reference to the time. That okay, that act, that statute was applicable at that point of time, but with the change of time, right, sitting in person also means in video conferencing you are face to face with each other and you're talking, right? Try to match the characteristics. What do you do when you're sitting in front of each other? You never clap each other, right? In the board meeting there's no point of touching each other. All you need is you need to hear each other, you need to see each other, and you should have a face to face discussion, and that is very much possible even in video conferencing, right? So that is the meaning of this rule. So if you continue reading on your screen, you have to read and interpret as it would have been when it was enacted, and then compare the situation today and apply it accordingly. So what do you notice over here? That yes, this rule is applied basically when the language of the old statute is ambiguous, right? It is not specific, it did not provide for all the specific criteria over there, so it is ambiguous, and hence you can take the advantage and try with an interpretation as per Contemporanea Expositio, right? So since your statute that was once enacted cannot be amended over and over again every time, right, They will amend it when they need it and when there are a lot of amendments to be made. For every small single point, they will not go on amending the statute. So for that, what does the law generally do, or what does the legislature generally do, is that they issue circulars, clarifications, the press notes and stuff, right? Then you will have to pay good attention to these things that are coming up, the journals that are coming up, right? So these interpretation of statute, these documents have to be referred. And when you are talking about the time period, right, it was an old time period when the statute was enacted, so you will have to give due reference to what has changed in the similar situation over the time, right? And you will have to also give due respect to the intention of the legislature. What did they actually mean by enacting the statute or by including this provision, right? So in the current scenario, how is that provision being accomplished? How will you fulfill the task? And once you know it, you can interpret the statute in the same or similar meaning, right? And at the end, when will this rule of Contemporanea Expositio not be applicable, right? It is when a new statute is enacted. It will not be applicable for the first few years. Why? Because if you talk about the time period, it is not changing so rapidly. That means not every few months or every second year the entire situation or the time changes, right? And your thoughts and your concepts go obsolete. That is not so quick. It changes gradually over the period of time. So if any new statute is enacted, right, you will never enter into such rules, right? Because if you talk about 2013, then that has been enacted and that has been framed with reference to the current scenario, with reference to the current time, right? Maybe 10, 12 years or 15 years down the line, you may have to get into an interpretation by using the rule of Contemporanea Expositio, because time must change at that point of time. Maybe the entire system changes, right? You don't know what is coming up, but as of now, as of what you know and as of what you have been following, even your Companies Act 2013 has been prepared accordingly. So you do not need to get into certain rules, right? The rules like Contemporanea Expositio, because there is nothing that has changed over the period of time, over the 3 years, right? That is all about the secondary rules of interpretation. We have done all the 3 rules, that is Noscitur, Sociis, Expressio, Unius est Exclusio Alterius, and Contemporanea Expositio. And I hope that is very clear with you. Now at the end, I will tell you one more fact, that you have not been asked a lot of questions on any of these rules in the past examinations, right? It's only once or twice when you have been asked questions and the answer was so general that if you remember the meaning of the thing, if you are able to connect what it means and you write it in your own language, plus you remember the name, then you are able to score. You do not need to get into a lot of details on the secondary rule of interpretation, right? Some of you must be thinking, why didn't you tell me it's the same thing in the beginning of the class? I would not have taken the class. That is the exact purpose why I did not tell you in the beginning of the class. You would have lost your interest in the topic, right? It was not asked a lot of time in the examination does not mean it will not be asked in your examination. It is a part of your syllabus and questions have been asked. So you never know, maybe it's your turn, right? So be prepared with all of it. Okay with that? So that's all about the rules of interpretation. We have done the primary rule, now we have done the secondary rule, right? All of it is done. So in the next class, we'll take up the internal external aid to interpretation and the remaining topics of the chapter. So please stay tuned for that, right? Because you have a lot of questions asked from the internal aid of the statute. We'll take that up in the next lecture, right? And until then, this is Abhinay Gupta signing off. Thank you and bye-bye.